Your Lordship can straightly come to page 177 and picture 5.
Just give a pencil. Just give me just 30 seconds. So your case is that you were declared as the successful bidder in the lottery because you quoted the same price with opposite party number 4.
Yes,
And ultimately you were asked to give additional security, performance security. You wanted to give it in the form of a bank guarantee, but the bank says that unless the letter of acceptance is given, they can't give you a bank guarantee.
absolutely.
You ask for an extension of a time or issuance of the LOA so that the bank can give a guarantee. But they have rejected your bid and awarded it to opposite party number 4.
No. Well, it's what they have done is, as far as I am informed, they have recommended for cancellation of my tender. They have not communicated any cancellation order to me. Or
Where is that letter? Where is that letter, the recommendation?
That is in my amendment application. The counter also they have given. Page 18 of the counter.
Counter is annexure.
D by 1.
Huh?
D by 1.
No.
Page 19.
Page
Page 16. It starts at page 16 of the
Just-
counter.
This is the proceeding.
By 1 and 2. 1, 2 and 3 counter.
Yes.
1, 2 and 3.
Flag B.
D by 1.
Annexure D by 1. This is the proceeding of the contract committee. Now, if you are over the page, at page 18, if your Lordship sees, in the instance case, last paragraph,
17 it ends, has not deposited the required requisite liable for rejection is the committee and recommended for cancellation.
recommended for cancellation.
Then
My lords, they have gone and floated another tender for the same work.
Let's look at two tenders. One will be due, second will challenge the
I'm told that they have withdrawn the tenders.
no, under the provision of a law, you are supposed to give an additional performance guarantee.
Performance security. Who will to give
Or whatever in the bank, you know, the by way of a bank guarantee or by way of any other bank guarantee. Where is the letter issued by the bank that I will not issue a bank guarantee unless LOA is.
Bank has verbally informed me. I have written to the authority.
Where is your letter?
That's okay.
One 79 is 179.
Huh?
179.
Page 181, annexure A. Your Lordship may take the last 7, 8. Your Lordship will see from this document that there is. Your Lordship will see from this document that there is no sentence saying that your tender is accepted. Subject to this.
No, they wanted it in the form of, in the shape of a demand draft.
No,
Not in
no,
the shape of a bank
that
guarantee.
your lordship sees,
Sorry.
at page 57. This is the format in which it is
This
to be given.
177, they have made it specific. Page 177, first, third paragraph,
Yes. Third,
they have confined it to, in the shape of demand draft.
no, well, it's, your lordship has seen
both,
previous paragraph.
no, no.
7 days of issue as per clause 8 of NIT.
Where is
number 76.
that? Where is that?
Yes, but that is exactly what I'm showing to your lordship at page 37. 57, sorry, ma'am. Page 57.
57, sorry.
This is the format. Page 28, your lordship, my first please. Page
Sorry,
28.
this letter of acceptance which we are just previously referring at page
177.
Okay. Now 57.
Page 28. 28.
No, 57 is format.
This is the format, but I come to the format after I show to your lordship the relevant clause.
Then you are taking us to 20.
Page 28.
Yes.
Clause 8. Your lordship has that? Clause 8, page 28. Additional performance security shall be submitted to the bidder when the
So
bidder.
there are three formats which are given to you, sir. There are three options. One is in the shape of a demand draft, you can give it in favor of payable in favor of Odisha Construction Corporation Limited. You can also place the term deposit receipts in favor of the said company, or you can also give a bank guarantee in the prescribed
Yes,
format.
sir. And the option is bank guarantee. And when they ask for the bank guarantee, ask for the security, I wanted to give it in the shape of bank guarantee. I approached them.
Why you did not give? Because now the bank guarantees will have to deposit the amount. You can give it in the form of a demand draft.
I already have that by way of deposit in the bank.
True, you could have done it a demand draft.
But
You can do it in a term
I
deposit.
could have done, but
You can place it with the company.
when once they
Can't-
give me the option.
I understand, but if there are other options which are available, then those should be resorted. If the bank says I can't, but treating as an LOA, you could have
No,
given it.
it cannot be treated to be an LOA because the LOA has to have a number, which is also, if your lordship sees page 57, kindly see page 57. This is the format of the bank guarantee, which says while accepted while. Where is that number or the date on at page 177? It's not there.
So they themselves is asking.
Nowhere does it state that it is a letter of acceptance or that your tender has been accepted, you are the successful tenderer. They have relied upon certain documents saying that on the basis of this, other tenderers have given. Your Lordship may see those documents. Each one of them states specifically that your tender has been accepted or you are the successful tenderer. Annexure 5 does not say that. It cannot be treated to be a letter of acceptance.
Anything more?
Yes, my lords. Now, my lords, in these circumstances, if they cancel, my lords, what your Lordship can exercise the jurisdiction.
That we know. We know we can exercise, but all depends upon the facts.
Yes, sir. The facts are this, my lord. The facts are this.
Burden us with the series of judgments. We'll consider it.
I prepared a compilation. And if one series, if your Lordship will just have a look at the counter affidavit. Kindly see at page 21 of the counter.
Yes.
With reference, first paragraph, with reference to the above cited, it is to intimate that your tender for the aforesaid work amounting to so and so only, being so and so less than the amount put to tender, is found to be the first lowest.
Yes.
Now your Lordship compares this with Annexure 5, page 177. I am directed to intimate that your quoted value for the aforesaid work is so and so, less than the amount put to tender. Stops at that. That it is the lowest tenderer, that this is the letter of acceptance, has been nowhere spelled out.
Yes. Yes.
So it stops short of saying that it is a letter of acceptance. In such circumstances, when there is no letter of acceptance, the question of asking me to furnishing the additional performance security could not have arisen. Now, my lords, even assuming that additional performance security was to be given, assuming that to be that, I had the option under the tender conditions to give it by way of a bank guarantee. And I wrote to them within the stipulated time saying that this is the difficulty which I am facing. Kindly give me the letter in the format. I will do it. I am ready and agreeable to comply with the tender condition.
Yes.
That's all.
Thank you. Who are you? Yes.
Kindly see Annexure 6, my lord, page number 179 of the writ petition.
Already read it.
My lord,
You did not have to. Then I have read it. Then what more? That's the only.
They are stopped, my lord. The captain of stopped. First. Second thing, my lord, this is their date chart. In their date chart, they have mentioned on 6th of July 2024, the lottery was held to award to the person. Lottery held L1, their L1 was finalized. On 26th of 9, they wrote a letter that the opposite party number intimated the petition that owing non-submission additional performance security, the deed of the petition is liable to be rejected. On 26th. On 27th, after expiry of 7th day, on 27th they approached that the petitioner intimated that as the letter 18th of September 2024 does not provide that it is the letter of acceptance or fact of this acceptance is not provided from the said letter. the bank denied the request for issuance of bank guarantee as additional performance security. They have not annexed any bank requesting letter. They have not also annexed any bank rejected their letter. They have not annexed, my lord. That is most sufficient. Categorically, they have mentioned in Annex of 6 that they are facing some financial problems. For that reason, they want to extend for 1 month. Extend for financial, due to financial problem. On 26th of September, contract committee cancelled the tender. And that should not be, that is mentioned in page number 53. There is an issue of addenda, corrigenda, cancellation notice. The officer inviting the tender may publish any addendum, corrigendum, cancellation of tender in the office notice board and in the website, such and such notice shall be form a part of bidder. So tender cancelled on 26th. Proposal given on 23rd of October, tender has been cancelled. There is no opposite party, there is no arbitrary matter. So, with arbitrary, we have cancelled this tender and we have given another party. Like alleged opposite party for opposite team. But there is no such circumstance.
You have not given it to anybody.
No matter, that has been cancelled
That is been cancelled.
on 3rd of October.
3rd October.
Yes, the decision was taken on 26th and 3rd October it was cancelled.
Yes. That's all.
It's like one of sir, he said that I did not make the application within the stipulated time. It's 7 working days. So 27th was within 7 working days.
Yes.
But,
Yes,
yes.
that before cancellation, natural justice. His judgment, this other is enclosed. Says this.
What more? You have made extensive submissions for
No, just
last.
one last thing. In fact, after this, they have floated tenders twice. Both the tenders have been cancelled. Now, my lords, my rate stands firm. It is the experience. Your lordships will take judicial notice of the fact that whenever a tender goes on progressively, the rates go up. It will be a drain on the state actually. That's my life.
He's putting out. Why you are citing ABL? That the court can exercise a writ jurisdiction in a contractual matter. Page 38 of your compilation of the judgment.
Yes. Para 23, clear from the above.
Because it does not relate to a cancellation actually.
Yes, ma'am. Obligation law act fairly justly reasonably, which is the requirement of Article 14 of the Constitution. Therefore, if by the impugned repudiation of the claim of the appellant, the first respondent as an instrumentality of the state has acted in contravention of the said requirement of Article 14. Because bank guarantee, if they are saying something else for me,
This is something else because this is something else.
but here I would also invoke Article 14 in the sense that the tender condition says bank guarantee is acceptable. Now they cannot, after acceptance of the tender, discriminate because in all cases they are accepting bank guarantee. In my case, why should they pick and choose and say that you will be subjected to a bad demand draft?
Discriminatory part.
Discriminate.
I was wondering when you are citing this judge.
They have acted arbitrarily by asking only furnishing of a demand draft as a it case.
There is optional demand or term security.
No, he's citing a judgment. That's why I'm thinking that once he cites a judgment, that it becomes a duty on our part to deal with that. Whether it will apply or it will not apply is a secondary factor.
The next judgment, that also page 71, paragraph 71. Abuse of bureaucratic power by insisting that you pay, do it by through a demand draft is an abuse of the bureaucratic power.
Yes. Para
71
of
page 76 of my compilation. There is the fourth judgment.
yes.
From a consideration, the aforesaid facts and circumstances clear that there is an element of abuse of bureaucratic power behind subsequent change in the tender allotment. So I'm saying, Maharaj, the tender conditions contained permitted me to furnish a bank guarantee.
And what other paragraphs so that we can deal with that?
Para 69, 67.
No. 6. You have referred paragraph 671.
Yes.
No difference. Other judgments?
Other judgment, the fifth judgment, para is 69.
Para, that is the subodh.
Yes, Subodh, yes.
Yes, para
69, 71. And then paras 1,
just 69. Just let me reach 69.
128, 129.
Yes.
And seventh judgment,
And para 88.
128, 129.
128. Oh, that is a reproduction of 1990 Star Enterprises judgment. Anyhow, then.
And then, Manoj, the last judgment, page 146, Manoj.
What?
this is para 8 onwards. Very different judgment of your lordship.
Para?
Para 8.
Page?
Page, well, para 8 is the page 146. Page 146.
Yes.
And the last one, that page 163, again a judgment of this honorable court. Para 6, without affording me an opportunity, they have gone on to cancel the tender. So para 6, para 7,
Yes.
para 8, para 9,
So,
and para 11.
so,
And this judgment has been upheld soon.
Item 2.
Yes.
By the petitioner is the licensing respect of a country liquor shop.
Country liquor shop.
Country liquor shop. Admittedly, there was a shoplifting of MGQ.
Admittedly.
Admittedly.
Yes.
Accordingly, the state raised a demand to tune up 2 crores 26 lakhs for against this shortfall. Then I deposited the entire amount in 2 phases. During
Two phases.
Thereafter, your lordship knows I am liable to lift the corresponding MGQ since last week your lordship has decided 10 cases where they had paid 50%. My lord was pleased to pay the another rest 50% and their license was valid till 30th day before yesterday, my lord. But my license is valid for another 5 years. But this time I have emerged as a successful lot to
Again.
again.
Item 1.
Check out.
Full payment. What are you talking? Not even half payment. Yes, see, your interest is fully protected.
And they have also admitted in the counter, they have received the entire amount.
Look.
Yes. Yes, this is the lordship has seen the counter.
Huh?
There is no question.
Mr. Swine, let me understand. Simply deposit of the amount is not an acceptance.
No, he has deposited the amount.
Why you have accepted? You could have refused that I will not permit you to deposit.
No, they have not refused to permit him.
So
He
that
has
means an
deposited.
acceptance.
They have accepted that. They have
So
deposited.
say that. You say they have deposited, we have not accepted. I was surprised with that.
I say there is no question of disputing that. He has deposited.
Page 10 of their counter, last part.
What to do? Give him, permit him to live.
Already there.
It
Now it's other
it is covered by your lordship's judgment.
Give.
So,
Yes,
whole thing
yes,
is
ma'am.
that let me take instruction with regard to the present.
This
Nothing. He says that he has we will record if it is there.
Keeping
He'll say in the event it is already been successful for a further period of 5 years, then you'll have to.
lordship, sir.
Uh, record from here. The,
Item 3.
Item 3, can you also look to the order dated 27/4/2026? The WA 440, it has come down below. The batch of cases, you also heard this matter and passed this order. You also look to paragraph 4, 5, and 6. That order then will also.
Yesterday was a spoiled whole day for all these matters, huge matters. The galaxy of lawyers, they started appearing. Today also, I think this will consume.
I don't think so.
I don't think so.
Lordship already has the notes.
27/4/2026, order number
Our submissions.
Really?
There is very limited. They are very.
Oh, that you think.
Let me press.
Allow the petitioner to place first.
Order dated, Mr. Rautre, order dated
Order dated 27/4/2026, order
26.
number 3.
27/4.
Yes, yes. 3 or 4, 4, 5, 6. 4, 5, 6. Since.
Yes.
Today, Maharaj, we are limiting also para financial.
Yes, I got it.
Yes.
I got it. Then,
We are here today because of para financial.
We have already.
true, I understood. So what is the
Today, what have they done?
mitigating circumstances which warrants the interim order to be passed?
They have remanded us back.
29th, where the matter was listed.
Who is for the state? Or what is the authority actually?
That we see the.
State or,
In block, if you revert.
no, state is the authority or what?
State is the authority.
State.
What
Who
is?
is, yes, Mr. Swine, if this was the observation at that point of time, even if we request the single bench not to proceed with the hearing,
Yes.
then in that event, how can you proceed in haste?
After that proceeded, gave them promotion, created you are as a reserve category. And reserve category.
When the matter was already at the verge of the conclusion, the court has recorded that.
Written notes have been filed.
Never seen such kind of order.
Just a minute. No, can you see the order that 27/4/2020?
We have seen in paragraph 5, I am just reading. After reading the paragraph 5,
6.
yes?
However, it is made clear that listing of those matters along with existing writ appeals shall not be a ground for taking adjournments by the appellants appearing in those appeals as they are appearing today in court.
To cooperate,
And to cooperate.
then what is this?
It was there that no further time will be granted on the request of the council.
So true, I understand.
Again, time was taken for
Sir, next order,
next order.
consent of the parties, you consented it.
Then
You consented it, sir.
that what Lordship says
Then-
is true.
What saying means? Mr. Swine, I am very serious on that. Don't take it so casual.
But on 29th
When you utter a word that what is your lordship is saying, then I have to be very careful.
order, that order is.
If I have recorded the consent, I know me.
Yes.
I'm very cautious and very particular about it. Unless there is an express consent, I never record consent.
No.
This much I can say. I take an exception to your words, Mr. Swine.
Sorry.
I take an exception.
Sorry.
Since the day one, I am very particular about it. I never record consent unless there is a consent
That comes.
in open court.
But he was not there, the other government council.
Whatever be, these words are not very, I do not appreciate in the manner. Accusing the bench that there is a wrong recording of the consent, Mr. Swine.
Sorry. The authority was time has been taken and matter of fixed. And the order itself is that Lordship, turn to the.
Sir, on each day, we have said, where is Mr. Saswata Das? You can't take the different stand. Brother, I can't.
They thought that they should have, on the paper, I say that they shouldn't have done it. But I think why they have done it, they think that promotion order issued shall be subject to final outcome of the WPC number so and so. By writing this, they have done it. They have the wrong impression that they can pass this order, that they have done it. Because every issue.
Taking a person,
Yeah.
read the field.
This order subject to REIT appeal number 4,
This case.
all the REIT appeal.
All these.
All the REIT.
It was the understanding they do not do anything.
Malad is the.
Not the REIT appeal.
It's a get it.
You read WPC and I thought.
Malad,
It is wrong.
it is
No.
the spirit
This
of
is
the order that should have, ought to have been honored.
Respected.
If they are constituting this manner, then what can we say?
Right, Lordship is rightly looking for the person who was present on behalf of the state on that day. Because there was an express understanding, exchange between the buyer and the bank. The situation has come where your Lordship needs to stay the judgment and also gives. And it should be.
Reverse order will kindly see.
This both the.
Pre-post process.
29, the case was adjourned. Interim order was
But they are passing this.
30th afternoon, they passed the order. And knowing fully well that it is only on Monday that the matter would be taken up. What was it?
Overreaching
So-
judicial proceeding.
At least there should have been some amount of respect should be given by the state government to the bench.
Objection to the IA filed by them. I'm filing today, you are kindly consent. That is, they are filed in all these three writ appeals.
The first three, the order, the
Promotion,
is from the.
promotion about which my lord seniors are mentioning, that is dated
Annual
30th
increase they have done it.
June 2026 in respect of Water Resources Department. And there, my lord,
These are all our water resources.
yes, I don't dispute that. But
Fine.
kindly see, my lord, the very same common judgment that has already been implemented.
He's very, that the place where he's appealing are good than others.
He knows well
You know,
that this matter is understood him and it is posted.
Yes, yes.
And the outcome of
Subject to the outcome.
the adjournment also he knows. Perhaps we will also say that legal address.
Yes.
Dispute is allowed. Several. This relates to promotion of the assistant engineers to the post of assistant executive engineer. A great award. But while effecting promotion, at least my lord, that the two letters issued by the SC and ST department clarifying the concept of own merit of the criteria and promotion rules was taken into consideration. And the main contention was that the reserve candidates cannot be considered as against unreserved vacancies. The Honorable Court there several points were argued that these letters are beyond the scope of 154, 158 of the Constitution, 162 of the Constitution of India. And it was also argued that this violates the principle of reservation and Nagraj and the journal decision. And it was also argued that Civil Tribe Department is not competent to issue such a clarification. And then the Honorable Court held that letters were bad, that might have, that is not expressly written, but the inference is that it might have influenced the judgment of the DTC. Therefore, all decisions taken for giving promotion after the issuance of the letter has to be reviewed. And promotion can, one line was very important, that a person who has been directly appointed only on merit and not as a reserve candidate and promoted as on merit can be considered for further promotion. And any person who has availed reservation earlier can never be considered for promotion. Can never be considered for promotion.
On merit.
Under the unreserved.
Yes.
They will be considered as against reserve,
Not
not under the general category.
Yes.
What is the clarification? Clarification was based on the law department's opinion. Administrative department asked for the opinion. Law department referred the matter to the scheduled caste. Scheduled caste conducted. But then our contention was that so far as what was challenged before your mercy is that that should not be a
review.
that should not be any reservation, not in the capital. The petition itself, that should not be any consideration for reserved candidates as against general vacancies. So the Nagraj and General Singh will apply only when allowed. I have asked that question several times to me, that if in the matter of promotion, you make a reservation, then the ratio of ascertaining the quantifiable data will arise. If there is no reservation in the promotional post, and everybody is considered as for general vacancy, where is the question of applying?
SC or reserve.
Where is the Nagraj or General?
Because everybody should be considered on where.
Everybody should be considered as. Then this second question, this is one. The second question that has to be considered in law, that can be several scenarios. Supposing I get appointed as on my own merit, through a process of selection, I get appointed. Then next vacancy is a reserve one vacancy in promotional post. I get promoted in the year 2000. Then another person who gets appointment in 2014 gets promoted to the post of the assistant engineer. just because I have heard reservation, can my seniority for 10 years will be wiped out and I will be deprived of promotion and no further promotion. What happens to the seniority position then? That has been explained in Ajit Singh Janoja. Ajit Singh Janoja says that if a reserve candidate skills a marks over an unreserved candidate in the matter of promotion, then if the unreserved candidate reaches the promotional post before he is again promoted, then his seniority will be restored by applying the catch-up principle. So then no injustice is caused. But if he gets promoted earlier, then the catch-up principle will not apply. And this catch-up principle will be in respect of the persons appointed in the same year or at any point of time. That is the question I ask myself. And to my mind and common sense, it says that if in one batch somebody has been appointed as a promoted, a junior has been promoted as a reserve vacancy, and then a senior person in the unreserved category reaches the promotion post, the catch-up principle will apply. But not against a person who has was appointed in subsequent years. Thereby, when I
understand. You say that if the year of appointment is one and the same, there are several vacancies, some of them are earmarked for reserve category of candidates. So their appointment is en bloc actually, but in a different vacancies they have there. Suppose if the promotion post is also shown a reserve vacancy, then if he is promoted earlier, because the reserve vacancy is first, he is promoted, then subsequently when an unreserved vacancy arose in a promotional post of the unreserved category, then the senior who is there in the unreserved, if he is promoted, then the catch-up principles must apply because he will be put above.
Right.
This is what you really wanted.
that is what Ajit Singh Janoja is. And I don't think that anybody will dispute.
No, we are
disputing.
We are raising one question, we are vehemently disputing.
Not at all issue.
Everything that is disputed.
Right, everything.
No, not everything,
So-
but we are taking this position.
I praise his argument, I was just making it more. Yes.
Then the third scenario is, well, I get promoted to the next higher grade.
No?
I get promoted to the next higher grade. I am being a reserve candidate. Then thereafter, the initial appointment in the junior grade is made by the general candidate. He gets
No, that maybe, if I please correctly, what I must do. Suppose the reserve category candidate is promoted because in the promotional post, it fell vacant for a reserve category. So.
No. That was general category. I get promoted either by way of reservation or by
No, that is what I.
So in the year I get promoted in the year 2030. Somebody is appointed in the feeder grade in 2015. Then can he still march over me in the promotional?
I could not understand. That is what I.
Supposing I am appointed in 2007.
Correct.
Then in 2013, a vacancy arises in the.
You are appointed in a reserve category.
I am appointed in the feeder grade 2007. Yes. Then a promotion is effected in 2013. A person get appointed, not in the promotional post, in 2015. That means after I get the promotion next year, he gets into the initial grade.
Correct.
then subsequently he gets a promotion. Can he supersede me to the next promotion?
No problem. Or where is the? I don't think so. If he is not born in the cadre,
That's what.
then in the
That has happened in few cases. That I will place to you also. And then what does the law demand?
Case can be taken up independently.
That three judgments of this honorable court of other benches and were imperium. Were imperium, even though they dealt with not with the reserve post,
but the unreserved post.
but with the unreserved post. Because they have not, on the ground that because they have not considered Nagras and general thing.
These appeals deserve to be allowed only on the basis of para 9.4 of the judge, impugned judgment. Only on that short ground, the entire judgment is to go. Because he has based the entire case by saying the laws written out in those two judgments are wrong, which in any event he could not have done. He is incompetent to do that.
Now, by this reversion or review, what has been done is scheduled as candidate as against scheduled as vacancies. General candidate as against general vacancies. So, even if a senior person promoted earlier to the petitioner 10 years before, he is a scheduled caste. He will be adjusted against the scheduled caste vacancies.
By this order, he reverted.
He has been
Reverted.
It's done here.
has been adjusted. Reverted back.
So,
The order that is before your
in
lordship.
that way, but general
Yes, sir.
category is treated as a reservation. Reservation for general candidate. The concept of reservation is that from out of the total vacancies, you reserve some post for scheduled caste and scheduled tribe candidate. And now, by virtue of this review request, what has happened is that general category is a carved out category which excludes scheduled caste and scheduled tribe candidate.
Let me supplement.
About 154, 162 of the article of Constitution of India and the observation of the launching so far as the other things, I will go into details if you want, lordship want me to. But that will be declared placing of persons has been reverted back.
Kindly see our right. The list of reverted officers are there. We are all working as assistant executive engineer. But on 30th of June 26.
Not in one go, like prior to the filing of the writ of appeal, some were reverted. So in installments they have been, and all of them are parties.
All of them are not. Kindly see,
Not in one go. See, installments, different departments.
Like, related to prestige.
Let me see that 20th. How abusive is this?
The person who had been working around. They were working in a promotional courses, how long?
Lord, yes, 9/7/2025.
9/7/2025.
I think this question is considered in a very different manner. Everybody.
9/7/25.
Plain and simple question like.
We are answering, well, substitute. 9/7/25. Provisional product competition.
Lord, page 25 of that, IAM law. Annexure
Actual
11.
aspect which was placed to your lordship is not correct. I can say.
I'll skip that.
This is complete. The issue was completely different in the.
We'll come to that. We have not placed our case as a
Something different.
We wanted.
Page 25 of annexure.
Yes, sir.
Page 25 of
Just
annexure
one.
1/11.
Now, they have done it. We will further records, and the no equity will come in their record.
Yes,
So,
yes,
this
yes.
right they have to clear. And it will be decided very shortly if you conclude the argument. We assure both of us we will implement within a week.
That's fine. That's fine. That's fine. That's fine. We will place my point right now. As per me, I'll be very quick. It is like this, bro. Kindly see.
Written submissions have already been.
Already been submitted. Your lordship, remember, your lordship said that the issue must be formulated. We have formulated the issue. Your lordship already directed.
We are now compared to work
Keep it
under
in the
our
record.
juniors. Keep this. We are now compared to work under our juniors.
I will say that.
Look, what I say.
And this is when it has been done, this order.
Yesterday.
Yesterday.
Yesterday,
Yes. Yesterday it has been done.
Observation.
Yesterday it has been given.
Yes.
Let me finish it.
Yes, we have already joined.
No, like, 4 days.
Well,
Within
What
a
is
day,
the reason?
Why
Why are there such a thing?
29th the matter was here.
That was the order.
my lord, kindly see that order.
29th, that matter was here.
My lord, kindly consider.
30th the order has been passed.
My lord, kindly consider.
We are thinking. that Over it, we will definitely.
My lord,
Submit one
the
thing.
fact that this order dated 30th/6/2026, which was passed, giving promotion, that says all these promotions are subject to result of these
We are not concerned with.
with regard to posting. The main question which your lordship have posed.
We were really at the verge of the.
Yes.
No, but I'm not there, my lord.
I'm just.
It says, my lord, consequent of
Reason to crossing order.
My lord, the order,
Day or day before you.
well, the order itself says consequent upon.
I know he says. What was the subject?
Yes, ma'am. Before the underworld single judge, we do not.
DPC of President and the DPC of 26-6.
Before the underworld single judge.
May I
subject
just
matter of
explain
challenge
what
was
the case is?
Two notifications by SCST department, two clarifications by SCST department. One,
About the DPC of 23-4-2026.
DPC was never challenged.
And the 26-6-2025.
DPC was never challenged. Promotion order of hour was challenged. Two clarification was under challenge.
That promotion order pursuant to the DPC of 26-6.
Correct, madam. Correct. Promotion order pursuant to DPC dated 26/4. Promotion order dated
May I read
9/7.
out the prayer, Miller? Prayer of
I'm
the
reading
writ
the prayer.
application, Miller.
That was done. And the ST and SC candidate, they were promoted.
You are promoted.
Promotion of 26-6-2025.
Yes, ma'am.
Yes. That is what the subject matter of challenge.
Challenge. Right.
Then this
Then-
is the DPC of 23-4-2026.
Yes.
Subsequent to the order of the single bench.
Yes. Review DPC. Review DPC.
Review DPC.
Yes.
That is what is there, and they have now implemented.
Enter that circular notification which we have given.
Yes.
Now, my lord, I was trying to tell what is the
Miller, prayer টা খালি পড়ে। মানে writ application prayer may I read out?
We are just thinking of the interim order.
Right.
Not necessarily.
But we have filed an objection, Miller, to the IMLR. You also just consider that. We have filed today, Miller. They have filed yesterday. We have filed objection.
The equal situation has arisen in this.
2 and 3 in this writ appeal, it relates to promotion from the post of HON'BLE to RI. So that is guided by separate rules and the judgment is also separate.
So we are concerned with this with
That will be made clear.
we are not concerned with the
But this will be heard separately along after this, right or what? Individually, it may be taken up.
Yes. We are passing some more of the very outset. There was more apart. But
Only the interim order was not,
Arrangement.
another writ application was pending and we will also be expected. That's it.
So
That's nothing.
I'm extremely sorry when the matter was called, my lord. I could not make myself present because of the genuine difficulty, my lord, I could not be on the letter.
you are not seeing anything. Completely on outside, so there was something which happened. Personally speaking,
So that they give it to-
I did not appreciate it.
My lord,
Not for you.
but at last occasion, it was brought to the notice of this honorable court that because of a order of personal appearance passed by the honorable single judge for implementation of the present impugned judgment, they produced a so-called affidavit that the review DPC has been conducted. Subsequently, this instruction was produced before this honorable court. This honorable court refused to grant any interim order, but your lordship granted them liberty. If any action is taken by the government, it is open for them to file an interlocutory application.
So what even I know that it was pending at the government level. So
Yes.
we said we were under the impression since there is no question of any implementation as of now in that way. So we say we are not going to pass any interim order. As we thought that everybody will cooperate and the matter will be disposed of in the meantime.
Your lordship was also of the
Because
view.
now the government, then we were conscious that in the event the government does so, then the liberty was given to them to pray for an interim order in this occasions were
Yes.
raised. Now they have done so. So finish.
Your lordship was also of the view that normally in promotion matters, no interim stay of the judgment is granted, but
That is what we also-
only subject to result of the final outcome.
But anyhow. Yes.
But this is the instruction which I received, my lord. There also they have referred to the previous order and everything they have, and they have proceeded on the basis, my lord.
Now we have passed the issue. Make you speak from 6.
There are a batch of writ appeals. Only in one writ appeal, this development
What
has
is sufficient? This is the advocate appeal. That we
occasion this matter has been agreed, your lordship, this matter is your lordship,
Sign that.
I have prepared a short note, but your lordship has passed the order.
No, that's.
Well, I pass on the.
Where?
Your lordship. Your lordship.
You have any? Page number 6.
Next section.
That relates to your documents.
Wrong, I have given a memo, other 6 matter is there. That has to be processed. I have given a memo. The wrong is
Similar.
similar. Same.
That's why
I'm giving that memo. Other 6 matter to be disposed as well.
you will appear. You will file further request and and decisions. The authority will decide if the legislation aspect or the all the
I have liberty to.
and all aspects.
I have raised the feeling of motion also.
Yes. All your contestants are also recorded. That you can do.
Same.
That will record late. May I also be review?
Monday we have filed the.
Today itself.
Sure, Budaka. In the light of this.
Too late.
Because all other 97, 98.
The lordship. But here the petitioner was licensed. Yes, no. But here what has happened? Lord auditor has raised an objection.
Synopsis.
Right. Petitioner was licensee of 2022, 23 was the outstanding liquor license. But after 3 years, in 2/9/2025, the audit officer has verified the stock register and now he has raised an objection. There is lordship. Yes, lordship. That I have registered, I have enclosed. The Mohaflower register, it is as per lordship, it's number MFV, Roman V, not at page 15, annexure 3. Lordship will find the opening stock and in the next page, page 16, closing stock is there. And Lord, they are saying this register doesn't tally with the online register. Online register also have enclosed at page 17, Lordship. That also says the stock same position, 1324. So there is no discrepancy at all. But I filed Soka's reply. That is not considered, and they have just reiterated the Soka's thing has been in the improved order. Lordship. Annexure 6, page 22, paragraph 2. You have been intimated by this office letter 99 to submit show cause reply on shortfall of 690 quintals of Maha flour. While there is 2014 quintals of Maha flour in MFB register and online stock in e-evoker portal is 1324 quintals, for which there is loss of revenue of 9 lakhs towards less stock entry. No, there is no less of stock entry. Both tallies. The MFB register,
From 16 and 17.
your lordship, MFB register and the e-evoker,
The number
lordship.
is 16.
Page 16, lordship, at page
Total quantity is
1324 in the left side. 31,323. Date was fixed. And online lordship at page 17. 21,323. Opening balance was 1524. And I have taken 200 for utilization. And the balance closing was 1324. So it is tallies. So there is no discrepancy of 600. Some they are alleging now. And are now demanding 9 lakhs.
Well, this is only a show.
Your lordship, 31st March 2023.
Last entry is 21st.
Your lordship.
Oh.
Because
it remained
yes, lordship. After I have taken for utilization 200 quintals and the balance is 1320.
But this is page 22, which is impugned before lordship. That is with regard to consideration of transfer of ownership.
No.
Yes, that is under challenge. True, but the so-called notice was issued to him, but he has not given any reply to that.
Reply annex of 5.
And again, a so-called notice on the same thing has been issued. Let him make the submission there.
What?
The so-called notice was earlier given to him, but no reply was given. That has never been submitted. No. That has never been submitted. My instruction, that has never been submitted.
Annex of 5 is there.
No submitted. No endorsement is there, nothing.
No endorsement. Yes. On 26/9 I have given, my lord.
There is no endorsement that we have received. My instruction that has not been received. The instructions. Yes.
But it has not been stated that I have not filed so cause reply in the impugned order. At page 22, annex of 6.
Page 22 is not the impugned order. It is
Yes,
only
it is
a
the order.
so-called notice. You satisfy this for the purpose of transfer of ownership of the shop.
They are directing to deposit the dues.
No. It is so-called. No direction is given. No direction.
You have not indicated and should see it that they did not find any.
I have received instruction.
Is that to submit a sugar reply shortfall of which
There is a loss.
this part there is a shortfall.
Yes.
Since you have operated two from outside the district.
But you have a,
Right for transfer.
That is not
From
it needs for
clarification. Hence there is a clear government
dues
But I am challenging para 2 only here in this case.
to
has said that he has submitted the reply.
He has not, you will also may add it that the reply will be considered by the authorities.
At this
But my instruction is that he has not submitted the reply, no endorsement is there. But in the paragraph 2, although it is not indicated,
But he just said.
How you have-
to submit the reply.
But it has been, no endorsement is there, and Lord, I also admit that. But it has been filed. My instruction from the client is that it has been filed, and Lord, this register also filed. We have filed, showing there is same is quantity is there in the Mawa flour B. Lord, it was given to Superintendent Excise because Superintendent Excise issued the so cause notice under Annex 4.
You know that.
It will say, no, if it is, Lord, it is again considered. I don't have also no objection. Lord, you may direct that. Let them consider the registers and my so cause reply.
so far.
There's a two is concerned.
Yeah, Lord.
two is concerned.
Not in respect of one, I have filed separate case because that is transport fee. That is a separate case I have filed. It has not come. Yes, Lord. So in respect of 2, I have challenged in this writ petition. And my lord, they are saying in the Sokals that there is a 2,000 quintal. That also they are registered that they have not supplied us.
What? So everything will be given to you.
Because my lord, after completion of year, my lord, we are submitting the register before the authority. Yes, Lordship. Every year. After year completes, we are submitting the register before the authority. And that, no. And my lord, the allegation of that there is 2,000 quintals, that register they have not supplied me. Whatever with me with the Xerox documents, I have given, my lord.
Was in relation to suppose of 99.
Yes, Lordship. Sokals is dated 99 Annexure 4, page 18.
And the reply is given on 26/9.
Respect of our.
Yes, Lordship. That paragraph 2, the impugned order.
Have been included.
Yes. Sokals related to Millard only that, and they have decided on paragraph 2. Other issues Millard is separate. I have filed also separate case.
But they have decided other issue.
Yes, Lord.
Not there in the issue.
Yes, Lord. That also they have decided also.
No, this is.
For that I filed separate case also.
This is for the consideration of transfer of ownership. For the purpose of. Yes.
Page.
Yes. Page 18. Yes.
This is the show cause we should. Departmental audit department has pointed out that opening stock of the Marua was such as well the online which is this much of efficiency and the amount of skill like is important. You are therefore liable.
This is only ground. Yes. For that purpose.
Order and order 22.
Yes. That order.
This is the reference.
Yes. That is while considering the
29
case of
one.
transfer, you have to comply all these things.
I do not know.
Since he has not submitted any reply, that's sufficient.
That
I fail to understand that you submit your so-called website.
Your Lordship.
Again, why did this order? Clear all government users submit your so-called advice so as to claim this document before the collector for transmission. Now, pending application.
No, I have not filed. Pursuant to this, I have not filed any reply.
What challenge?
Yes, Lordship.
The challenge is that you are integrated with there.
Yes.
Show cause was issued.
Yes.
Where is the order of that show cause?
When order, this is the letter they have issued to me. The license event is been issued.
No,
then
Yes, Lord. 21. 21. 21 is the objection to the Sokals. But I have written reference 29 of Audit Excise Department. And Sokals replied to letter number 99. The 99 is the annexure 4. Sokals.
correct.
This are,
this is not time.
that he has to include, he has not included. I have to take.
No, even your decision is not coming out
Yes.
time. From 22, it does not appear.
22.
Yes.
See, that's all.
It says directed letter.
Where is
29.
Decision is, they are not referred to the what decision has been taken, but they say that the notice was issued.
20. So
The final order with regard to that is not there. The final.
Yes.
Where is the 21 letter?
No, I don't have.
22.
Yes, yes, I have lot. I have already seen references. Reference.
So that is the source.
Yes.
That is the source.
The challenge is made to the letter.
Just one day before, Lord. 30th is the date.
With regard to other items, 1, 3, and 4, the other items just filed separate writ application. Let the number be given, so matter can be answered.
Lordship. Yes, yes, Lordship. Paragraph one, because it is a transport fee.
29 letter production.
That's what it is.
All these matters
Lordship.
we are on.
Oh, yes.
Similar matter is under your consideration and just
What is this list?
passing the order.
Oh, this
And this matter is tagged up. Similar matter is under consideration of your lordship. And this matter be tagged out.
Why? I do not subscribe this particular view of tagging on the, unless I look at the file and both the files, if I find yes, then I will. No, sir. What is the matter about?
Allot this matter. The application fee for excise policy. In 2021, it was 1 lakh.
Oh, you have challenged the virus.
We have challenged.
Challenged the virus of the clause 3.1
My lord,
of that notification.
my lord.
What is this notification? Where is that? At what page? Non-refundable fees of 3 lakhs they have done. If you are unsuccessful, then we will go.
Clause 3.1 is at page 44.
40?
44.
Three point one.
Non-refundable.
Yes.
3%.
Now, what is this? This is a guideline or what? Rules, what?
Policy.
My lord, this is
Or a policy?
policy.
Policy. Then
And the order is at annexure
annexure,
2,
page.
page 74.
No, this is what an order.
Lord, at page 79, 1, a non-refundable application fee of 3 lakhs.
No, that is, I understand. What is this order?
This
They call it a order. Where is your application which is turned down or?
Now, this is statutory order.
This is statutory.
What is a statutory order?
It's, instead of notification, they pass this sort of order to count.
No, this is really a notice inviting the applications. Sale notice. So it's not an order. It's not an order. It's really invitation to make an applications.
Challenging that part, which in 2021, 1 lakh application fee was applicable.
That was also non-refundable.
Non-refundable.
So now they have increased.
Now this year.
So what is the wrong in that?
Arbitrary increase of 3 lakhs. That is also non-refundable.
There should be. There are a lot of applications if you start giving it. What is the stand of the state? No advocate general is required to be noticed. It's not a statutory provisions, nothing. So
It is 1 lakh, there is an enhancement to 3 lakhs.
there is a fee. What is the difference between a fee, cess, tax? I think there are a lot of judgments on that, making a distinction between a fee, tax, cess.
My lord, there is a judgment of Honorable Supreme Court on fee and tax. If your lordship may peruse point 5, dealing with the distinction between tax and fee,
Where?
para 5. My lord.
Paragraph 4.
My lord, paragraph 4. Please ignore that. Tax is a compulsory exaction of money by public authority for public purposes, enforceable by law, and is not payment for services rendered. Whereas in fee, there is a requirement of quid pro quo. Fee is generally defined to be a charge for a special service rendered to individuals by some.
I understand, sir. If there is an option,
My lord.
there are one distinction which really appears in my mind. The tax is a compulsion.
My lord.
The fee at times is compulsion, at times is optional.
My lord.
It all depends upon the nature of the fees which is collected. This is what Sir Asutosh Mukherjee's judgment has been considered in paragraph 5. This is Sir Asutosh Mukherjee's judgment. So he has said that we cannot generally characterize the fees in a common bracket.
My lord.
It has a varied form.
Right.
In this case, it is your option. They do not put any compulsion on you. If you really think that you want to apply, then you should know that this is the fee. That's the choice is yours not to apply also. So there is no compulsion of the fee.
It's supposed to be based on the expenses.
That is what the last line.
One more line, if I may. The fee is regarded as a sort of return or consideration for services rendered. Here
So
the
that is what a distinction has to be drawn. One is which
out of return or consideration for services rendered. Here the services rendered is only hosting a server for applying online application for lotteries.
That is why each industry has said that that quotation coming now to fee. That quotation. The fee is generally defined to be a charge or a special service rendered to the individual by some government. The amount of fee levied is supposed to be based on an expenses incurred by the government in services. So in many cases, the costs are arbitrarily assessed. Ordinarily, the fees are uniform and no account is taken for variability of different recipients to pay,
My lord.
These are undoubtedly some of the general characteristics, but as there may be a various kind of fees, it is not possible to formulate a definition that would be applicable to all. So what is the distinction is we have to compulsion. The tax is the compulsion.
My lord.
If the fee is what is the character of a compulsion, then it must have a nexus with the actual expenditure with the government makes. If it is optional, does not impose any compulsion on you as a common man, then in that is should the court interfere, because here you have an option to apply, not to apply, that's your choice. If you think that it is the conflict, don't apply. Say for example, the Cuttack Municipal Corporation imposes the clearance of garbage fees, which is payable by all the owners or household owners of the municipal area. Compulsory. Then the fee must conform to an expenditure which the corporation has to make for clearance of those garbage. They are not fixed arbitrarily. But once it is an optional one, you think the court should interfere, the policy is no, sir. Tax is one, fee is another. That's why I asked, what is the distinction?
My lord. My lord, there is one more thing. In 2021,
Anyhow, I told you.
they issued a notification by which they introduced a lottery system and 1 lakh fee was charged. In the
You did not have any of this when they were charging non-refundable 1 lakh rupees forever.
no,
You are coming up to when they need this 1 lakh rupees. According to you, it is a arbitrary enhancement of the fee amount. Now, question is of object and the purpose. Object and the purpose which I, or rather, if the client's what I perceive was this awarding this particular the liquor shop, it involves a payment of an excise duty by the owner.
Right.
Thus, the solvency, the capacity to pay can also be judged whether a person has a capability to pay. So if the person who has a capability to pay 3 lakh rupees non-refundable, at least some kind of a solvency is presumed in him. If that is the position, then there is a limit.
my lord, after
1 lakh to 3 lakh, 1 lakh was fixed when?
2021.
Now, after a gap of nearly 4.5 years or nearly 5 years more, 3 lakhs. 3, 4,
I buy down to your lordship. My lord, after the application fee, after the lottery winners, thereafter they have to submit a earnest money. There they can show their solvency. But here in the preliminary stage.
It makes many times the experience so that it becomes a cost to the money. When the person who was lucky, I always say lucky word, fortune, which will come, does not submit the request, then in fact the entire process become a fast necessary. So if I want, then one must be ready that yes, I can forgo. Let me test my fortune.
My lord, can I bring for an adjournment?
After Army,
My learned senior.
why you was after Army? Why you starts from the
One short.
who is yours name?
Learned senior Mr. Pale. He's on his legs.
It is also admitted and it is posted to 9. But I have challenged other points apart from this lordship fees.
Notification of the draft.
That is page 20. Annexure 5. So only limited to the on-subs organizing musical programs and orchestra. After careful consideration, government has been free to decide that in cases where provisions of the fire safety rules are not applicable,
Why you say the fire safety rules are not applicable?
kindly see the fire safety rules. But you could look at rule 9. Just kindly see the commissioner's order, annexure 1. Before I take your lordship to the rule, I think commissioner is writing something which is not there even in the rules. I will be subject to correction by state council. Page 12, lordship would kindly see the commissioner's requirement. Commissioner writes,
So they say that Orissa fire prevention and the fire
safety rules.
means that every command is established. And in the public movement. Knowing all the flammable spirituous items is required to install a fire safety.
This is not there in the rules. This is not there in the rules.
And obtain a valid fire.
Yes, this clause, the commercial establishment holding public movement, storage of inflammable spirituous items are required to install fire safety measures in the premises. This is not there in the rules. Kindly see. Rule 9. That is at page 6. And there are also exempted categories. Yes. For the purpose.
So they say for the purpose of this section 10, incidents are likely to have a risk of fire, which includes hotel lodging and guest house. You
Yes.
are a hotel,
But I am an on-shop.
what, hotel.
Hotel. But it will come. Hotel is a genus, on-shop is a part of it. Basic. Hotel.
Are you not providing any lodging?
Yes. Lodging is also there.
It's not a restaurant.
It has to come under the category of
Not a
hotels.
restaurant.
But the exception is there, just see Roman 1.
Roman?
Roman 1. That has to qualify this of 12 meters or more in the height from the ground level.
No. Roman 1 now?
That J plus J, rule 9(1)J. Hotels.
J. Involves shopping complexes and mercantile buildings.
Lord Lordship has seen hotels, I.
I fails.
Yes, where at best will come in the category of hotels, lodging and guest houses.
Yes.
Kindly
Of meters of home in height on the ground level.
Yes.
So,
So we are not kind of hotels of 12 meters or more in height from ground.
meters is nothing there.
12 meters means
36.
36 feet, 40 feet, almost 40 feet, then 4 story.
You are only a ground floor or a first floor.
Well, that's what I'm saying, that I'm not coming in the category mentioned in the exception.
So what you are saying, that only first floor or a ground floor or a what? So you are saying not refused.
That specific instruction I don't have, but they say that we are not coming this 36 feet, 12 meters back. And we are operating since 94, not prior to this 2017 rules coming into force. Then what is exception?
That is income.
Breakfast.
Thing is income.
No, we have installed fire extinguisher.
Instead,
Fire extinguisher we are.
see, so far as safety is concerned, neither your lordship nor we can compromise on that. We are prepared to do minimum safety, whatever is required. We are also prepared to do that. We can't take the risk of, but these traditional cities, old buildings, they were constructed long back. The lordship knows the situation there. The road are definitely narrow. The buildings have come up much prior to this building regulation rules comes into force. And they are all existing, at least we are concerned, 94, 95, these licenses are there. But if at all if the lordship sees rule 12 of this rule 9, sub rule 12, but we are prepared to do the minimum safety, whatever is there.
Existing building.
Yes, some kind, yes. But kindly see rule 12. There is also a relaxation clause at the end of the director. That is there. Let them tell us that these are the minimum safety you are bound to have in our building. That will have it. Instead, they are straightway saying that we'll close it. They must give us that these are the safety you follow, you install. That we will do. It's excise authorities of their own way, in their own way, passing orders annexure to my lord specie, they are giving deadlines that will close it down.
This means for the state.
Let's wait for the statement. And it's here, first point, my lords, the petitioners have already given an undertaking that they will submit the fire safety, and accordingly, the collector had extended.
Something beyond the purview of law.
No, my lords, that, yes, ma'am.
What,
My lords, the 2000.
undertaking in terror.
No, my lords, that is willfully they have given undertaking requesting for time.
Undertaking in terror.
No, my lords, if I may submit the instruction along with the.
One of the case lordships have
Sure.
also passed an order.
Sure, the provision of law that really covers this case. We are very sensitive so far as the safety measures are concerned for our devices to be installed. But if some buildings are outside the purview or does not come in that way, And threatening, I can understand that you will invite, threatening to close it. If you need a closer, then there should be a provision of law that has to be. What is the provision of law? Which section permits you to closer? Sure.
Well, it's on, well, it's.
It is if you the order is follow up
Annexure one.
Yes.
Annexure two.
Madam, where is the problem? Which problem?
Well, if Annexure 1 is an advisory in nature, my lords. They only say Annexure 1, my lords. It only says that as per the provision of Odisha Fire Prevention and Fire Safety Rules, every commercial establishment handling public movement, storage and flammable spirituals shall require.
Come to the include the order. First sentence contains this. What is that? Well, first sentence, annexure 2 is the impugned order.
Annexure 1 and 2 both are the impugned order.
Whatever comes to the annexure 2, where the threatening is given for closure.
Yes, sir.
What is the first sentence?
It says commissioner wide order dated instructed that all licenses.
This is order dated means that is annexure 1.
Yes, madam.
So, and then the last line, closure.
Yes, madam.
How? Tell me.
Well, it's if I may hand over the instructions, my lord.
I'm asking the law, sir.
Yes, I'll show, my lord. I'll show the law.
Show us the law.
Yes, madam.
Forget about that's your instruction. You give us. Tell us. Which provision of law?
Well, it's 2017 rules, my lord.
Yes, we have our. This is in our hand.
Yes, madam. That has been amended in 2019, my lord.
Yes.
The amended 2019.
Have you given amended one?
Yes, it's there. Amended is there. 2019 amendment is there. I am grateful to my learned friend as well.
Give it.
19 is the lines.
Rule 9A1 has been substituted.
Yes.
In that manner, rule 3,
What is there?
surplus E last point, depot of petroleum, other inflammable substances. my lord.
Yes. Yes. Yes.
And it's sub rule 3 in that 2019 notification, my lord, amendment, my lords. 3E, my lords. It refers to depot of petrol and other inflammable substances.
Spiritus is not there.
Where?
It's sub rule 3
So,
in the
three.
in 2019 amendment, my lords.
We'll get Rule
3, 3E, my lords.
Rule 3.
Yes, my lords.
Sub-rule. Where is this?
Sorry, my lords. Rule 3, my lords. Rule 3 of 2019 amendment,
What
rule
is it?
E, my lords. This was
Depot of
the
petroleum
and other inflammable substances.
and refineries.
Yes, my lords. And refineries. Refineries. My lords, here again, my lords. No, my lords. I am referring to other inflammable substances only, my lords, here. Then, my lords.
Refined see that's understanding of the officer.
That is,
That's an understanding of the officer.
alcohol is generally inflammable.
The first terminology is depot of petroleum. You have to read entire
Yes, my
history
lord.
as a
Yes, my
whole.
lords. Yes, my
You
lords.
can't segregate.
No, my lords. I understand that, my lords.
I was very mind simply asking that one officer understood it. My brother becomes. If they come to you and give you instruction. And they take shelter under E.
No, my lords, I'm just referring,
I'm so sorry.
I'm referring to one by one clause. Then, my lords, H. Business or office building. K, my lords. Hotels, lodging and guest houses. And there the parameters.
This says I.
Yes, my lords.
He says much less than your.
That instruction, my lords, I don't have, my lord. They have also not submitted to the collector whether they fall under the exceptions or not. If they are claiming an exception, they could have approached the collector and said so. That is also not on record to say that they have approached the collector to say that they don't fall under. Manoj, if they're
The word,
claiming an exception under this rule,
there is an exception.
even in the writ
I'm
petition.
asking him. There is two kind of. One is substantive provision which applies. Another is certain exception is provided in the statute itself. If they apply a substantive provision and then they say that I come under the shelter of the exception, then they have to go and approach the order. But if the substantive provision itself is not applicable, then why exception? Why exception? I'm asking you.
Manoj, then I have to take proper instruction whether all
Because
these are.
their case is that these substantive provision has none of applicability.
These
You have to say that here commercial building will not do.
such
They have
grounds
to
not
say
taken in the writ
it is more
petition.
than 12 meters, people storage, one storage building. I can understand. Business and office, then medical, educational, then comes again. Same conditions are there.
Then my KL will also come mercantile building, my lord. If, my lord. That is as per my understanding.
What is the meaning of the market?
Wherever the commercial activities are.
Oh. You see the commercial codes and where the working time document and the word working time was.
Common meaning of the word I'm going as
I'm just asking, is the meaning of the document.
going by the common understanding
That's
grounds.
why I'm saying that so the commercial codes act, it says that commercial dispute will also be in relation to a mercantile document. And the word mercantile is not defined there because it defines to a judicials. What is the meaning of the mercantile is also defined in the rules. Yes.
Yes, my lord.
Face again.
Yeah.
Yes.
Under the exception is not taken as a ground in the writ petition, my lord. Hence, I have not taken that instructions, my lord. I'll take a specific instruction whether they fall under this category of exceptions. And there's only one more relevant provision under this rule is
Your actions should be within the confines of each regulations.
11, my lord. Rule 11 of 2017 rules, one provision, my lord. Rule 11.4, my lord.
That is amended.
11.4, my lord.
Earlier it was prior to commencement of the rules. Now it is 40.
11.4 of the rule reads that no authority or officer empowered to issue or renew a license for operation of cinema hall so and so, where mentions any business, trade or profession or any other activity whatsoever in a building or premises or part thereof as specified in Rule 9, unless is satisfied about the adequacy or operability of the fire prevention and safety rules therein and possession of a valid fire safety requirement. So there is a clause, Malice, the specific instruction whether this building falls under thus such categories or not, that instruction, Malice, I have to take, Malice. That I don't have. But there is a power given under 11.4, Malice. That is what I'm trying to do.
Yes, all respect. Provided they fall within the.
Correct, ma'am.
Right.
Correct, Malice. That
Yes,
is.
yes, if they do not come within the purview of rules,
That is the first time they're taking. They have not taken such ground in the writ petition. Malice.
Madam, that's parrot will will say.
Please, what case that went out, let us see.
See, parrot 12 we have said, madam.
Which page?
That page 7, that additionally.
It's very broad. Casual exercise or.
That's it. End of. That is what has been said.
It's really painstaking.
I understand.
Very casual way, I find.
I can understand that, but then states one is G plus one, other is G plus two. There are two cases, G plus one and G plus two. That I can, statement will be required.
You are thinking of a very broad.
Rule 9, but I take excuse that specification is not here, but then.
Hotel, is restaurant, what is this?
Yes, that is. But he said that is G plus one. But that instruction is only G plus one, then he says this. That can be recorded, you know, he said that statement can be recorded. Now they exclude that definite meaning is not there. That should have been there. I concede.
Well, what I find is here unless we get a specific case, no instruction which is sought on any other aspect.
Then not should record this.
So is regularly is done.
My instructions.
Not independently thinking even in the fees taken of a law, the requisite informations are not missing.
Well, has to be specifically there, but the statement. The thing is that we are running from 94, 95. But I can file an affidavit to that.
Being outside the purview of
The rule 9, but I can file, he can file an affidavit to that. But he can file an affidavit to that effect, but then before this, they should have some fact-finding inquiry on this. Nobody has done this. Neither the collector nor superintendent excise, nothing.
would have the fire safety devices.
Well, yes, we have.
Portable.
Yes. That instruction I have taken. I asked them, do you have? Yes, they have all. Every floor. But the specification I must clearly tell your lordship. With regard to that width of road and other things. That will not be possible, Lord. Now, at this point of time in the old towns like Baleshwar, that will not be possible because the road, several buildings have come up, age-old buildings.
Not going too far.
Not going too far, yes. Not going too far.
That will affect them also.
Yes.
Yes, but still, then we are passing a direction on your authority to give a notice to all other places where the safety devices.
It's regarding rule 9, I had taken instruction. They had given me.
Appreciating. Let me issue a notice to some other cases.
Well, it's regarding rule 9, I had taken instruction. That is what I had received and whatever I placed, my lords. This is what they had the understanding, my lords. And regarding that first impugn order, it is regarding everything. It is whether to check whether there is a fire safety.
Item 4, 5, 6, 7 adjourned to 9 July. Item 8.
Yes, Vigilance. Now, here, my lord, OP number 5 is a license in respect of an on-shop manner. Because of his prolonged illness, he intended to transfer his license in name of the present petitioner. According to Rule 42, he submitted an application before the collector along with the requisite is of rupees 5 lakhs. Lordships kindly come to Annexure 2, page 15. This application fee was made in reference to the excise policy 24-25 because the Lordship note for the excise 25-26 there was no excise policy. They have adopted the excise policy of 24-25 that is extended by the government. Lordship kindly come to Annexure 2, page 15. I have paid 5 lakhs on 15th January 2026. Then, my lord, I was intimated to appear before the London Commissioner for participating in a hearing, madam. On that day, hearing could not take place due to some official reason. Then, my lord, again I was intimated, I appeared, Lordship say Annexure 4. The imperial order they have passed. Second paragraph, inviting a reference to the letter of subject cited above. I am glad to say that after careful consideration, the Excise Commission of Orissa has been pleased to approve the proposal for transfer of license of drill, island IMFL onshore, so from the existing licensee Tushar Nath Dutt to the name of the Priyadarsan Acharya, the present prisoner, so for the remaining period 25-26 as per the provision contained of the rule 14. Yes, allowed. Subject to, next line, subject to payment of differential transfer of as per the excise policy 26-29. My application was within the ambit of 24-25. At that time, the fees prescribed under the excise policy was 5 lakhs. Now, the excise policy, now new policy has come, where that fees one-time application fee has been enhanced to 10 lakhs.
So you are writing for 5 lakhs.
5 lakhs. Because that excise policy specifically says it will be effected from 1st April 2020.
What is the MTQ?
Minimum quantity.
What is this MTQ for you?
MGQ, nothing, my lord.
Nothing.
No.
How much? For every year, MTQ, how much?
Lordship license I have annexed.
No, I've just, for some other purposes, I'm just asking.
It depends upon the
The MTQ is fixed. Minimum. Above MTQ is something different. Depending, but minimum you have to.
minimum and every
How
year.
much? How much?
So depends upon the needs of that area. It is fixed.
How much is allotted?
My lord, here Lordship may kindly to page 11. 600 BL, that is beer, 250, 25 LPL liquor.
600?
600 BL, beer. Bulk in liter. That is bulk in liter. That is beer measurement is beer.
Whole year.
Whole year. Now this is MD monthly man. Monthly. And then LP
600.
600.
What about the other?
Other liquor, as you can see, liquor is concerned 225 LPL.
Liter.
Liter. London proof liter. See here.
What would be the total cost of
That aspect depends upon the product. Product.
Duty and cost price.
Duty and cost price.
MRP laws. MRP. Different categories there, different category, different
I
MRP.
understand approximately what is the what is the average sale?
It depends upon the also it cannot be because
We're talking about somebody is going there and consuming it in your.
depends little bit. It is costlier than the
monthly sale. What is the amount of sale? The average previous licensing.
depends.
Sir, you have decided to take it by way of transfer. You must have gone to it. What is
Of course.
My lord,
how much profit
actually
it comes?
sales it varies
And you
from.
know what you have done behind the excise officer.
No, my lord. What I say, my lord, as my information goes, my lord, it varies from one place to another.
Oh, in this space, because licensing is running for a pretty period, many months.
Many months.
What was the average sale?
That aspect, I don't have any information.
10-15.
Or you do not want to.
But 10-15 lakhs within that
10 to 15 lakhs.
per annum.
Huh?
No.
For the public.
Because the area it varies. In rural area, lordship knows very, the margin of sale is very low.
This is rural area.
Jail Road.
Gujang Melon, Khurda Road.
Jail Road.
It's a Gujang Road,
What
Khurda.
are you talking? Jail Road.
Not
Jail
yet.
road for the,
Gujang Road. Gujang Road.
main area.
जेल टा टिके टाउन बाहर
Jail road लिखा है। अपना लाइसेंस देखो।
आएगा एड्रेस एड्रेस जेल
इधर नंबर पे।
आएगा
हाँ।
रेस्टोरेंट नियर jail of the address of the home, the residential address. Just below my lord. The restaurant license is near Khurda Gurjang Road. Out of the town. Town Bahar.
Samustag से to
Yeah, what do you say? How can you apply the new policy? That's people done under the old policy.
Because by the time the approval is granted for his transfer,
Then what is the law? Well, the application for transfer was filed.
yes, Mullah, I am aware of that law.
The point of
The
time.
game rules cannot be changed. I'm aware, Mullah. But here, Mullah, the statute is a little different. If Mullah will see Rule 42, transfer is possible only if the commissioner is satisfied. So, Mullah, making of an application does not gain any right in his favor. The day on which the commissioner applied his mind and Mullah, he approved.
Then in compassionate appointment also says that mere application will not do because it requires a consideration on various factors. So if the consideration comes after 5 years, then new scheme of the appointment.
Yes, Mullah, but here, Mullah,
According to you, it will be governed because on the date of consideration.
no, Mullah, in compassionate appointment cases, Mullah, it is dependent on one fact. It is, Mullah,
Altogether, it takes 4 months.
Mullah, we have done it before 4 months. We applied in January, Mullah, we have.
After expiration,
we have in April.
Also, see that excise policy have appended. Specifically says it will operate from 1st April to page 30 annex 8, the new policy which has come into introduce for the excise year 26 till 29. From 1st April, according to fees. Two 2007, 8 SEC, 593, 593.
Mullah, sir, I was relying on that 2003 three Supreme Court cases. My lords had cited that Balwant Singh and others, Mullah, Justice Khalid laws, that it is mandatory when a private person is concerned, but so far as an authority is concerned, if consequences are not provided for, then it has a directory nature.
Perspective. One judgment at 2025. Is clear, Mala. That is the state of Maharashtra versus Prison Cement Limited. Only paragraph I would like to show, Mala. Paragraph 7, 17, 19, 22, 23, 24. Time manner to.
I tell you, Will,
This is.
this is not a correct,
Already right
judgment
on the
which you are saying.
Yeah, apply.
The point is very simple here. What was transferred? License was transferred, but what period was that? The period anterior to a new policy term. Can the new policy have the retrospective operation? Imposition in respect of a remaining period of 25-26 when the policy of 24-25 was carried. If you impose retrospectively, that is the question. Bring the judgments on that. Assist us.
The license period is from 26 to 27.
Remaining period of 25.
That is what they're written.
Extended.
I've seen that.
26 to.
Oh, that is what I know.
But his license is that.
So on that, whatever is the extension, period of extension is required that you have to pay. But it is the transfer fees.
Yes, not the language manner one time.
Oh, I know transfer effect from the remaining period of 25.
Next week.
Whatever. Even tomorrow, day after tomorrow, I don't mind, but this is
Next week.
Adjourn to 9 July.
But we are also going to have challenged the.
Simply.
Yes. Yes. Paragraph 8 I have stated that it is a double-story building and it is less than 12 meters long. It is less than 12 meters. But para 8.
Oh.
Page repetition, but page 5. About 5 lines. That apart rule 9 of fire safety prevention and business office building having height 12 meters and above, and having built-up area 500 square meters or above, that the premises where the petition is operating is ample restaurant on sub, is a double-story building. But I have also given the lease deed, the rent agreement I have given also, and except to current operating lot. Because it is, I have taken on rent. It is not my own building lot. And Lord, it is of.
Yes, but on 9th may be taken up, some data will take construction. I have.
They have extended the license up to this month. Because of they'll have to renew my license for entire year, but they have extended the license for up to 31/7. And they are not. It's there.
Adjourn to 9th July. Item 10.
If there are actually for the petition on lordship, on that with my friend lordship. But very innocuous my lordship, this rate application. Only to collect to take a decision on my renewal application. That is at lordship, annexure. Appeal lordship is 61. Detailed dependency.
You wanted a renewal of your.
Grateful. Only that much lordship. But just lordship, can I give some little background of this case, lordship? I was the existing licensee lordship. Lordship can set up
Dispute with your landlord.
Yes, lordship. That is, in fact, lordship, that is a frivolous petition, and it has been created by the department. That I think that will start lordship.
Then what happened to that?
Lordship, kindly for a moment at the same time. Lordship, there are two. They had preferred a rate application and lordship criminal case. Lordship, the person who had made this complaint, lordship. Lordship, in fact, lordship, I am the owner of the property, lordship. That is the whole confusion. She had a very little portion of the property, lordship, and of the entire hotel. So that's why her claim was, lordship, kindly come to annexure 1. I have purchased the entire property, lordship, but somebody is claiming I have some portion of the property of that entire hotel. 0.1 decimil only her claim, lordship. Lordship, kindly come to annexure 1 is the record of right. Then lordship, all are the, and at the same time,
Yes, you can look at annexure 1, nothing more than that.
lordship, that is my property, lordship. That is it, lordship. Lordship. That is recorded in the name of the petitioner, lordship. Lordship, I'm giving lordship, just demonstrate the paper only, but the rest contents will be on the other annexures, lordship. If lordship kindly say, he starts from page 18 to lordship page 24 by the all time. That is the English translation. Lordship. There is no remarks. Remarks is blank. Blank, lordship. Yes. You said that along with this person, the name is recorded. Lordship. Another person is also. She is claiming, lordship. She is claiming only. So, lordship, kindly.
How do I?
Lordship,
How do I presume that you are the owner?
Yes, lordship. Yes,
Simply on the basis
No,
of the
lordship.
sort of guide.
No, lordship. I'm giving little background. At the same time, she preferred a writ application before this honorable court. And pursuant to lordship's direction, lordship kindly come to annexure 4, page 26. There is a lordship inquiry report by the superintendent of excise and details, lordship, are there, lordship. A detailed inquiry was made, lordship. It starts from page 26 to 28. Lordship, Annex 4, page 26.
Yes.
Then lordship, at the same time, she had preferred this writ application, and the second lordship, she has also raised a criminal proceeding, lordship, before competent court.
With application, challenging disorder.
No, lordship, no, lordship, because lordship, she had a lordship ownership over the property, lordship, and lordship making allegation against my license, lordship. She had preferred this writ application, and pursuant to lordship direction, this encouragement by this officer, lordship. By the Superintendent of Excise. Yes, lordship. Everything clear report in detail, lordship. Demarcation and everything is there, lordship. And ultimately, lordship, what happened, lordship? Lordship, can you come to the peculiar to the case? Lordship, I'm going to draw lordship's kind of attention to another document. While filing this criminal.
What is the show cause issued against you for this?
Lordship, in fact, lordship, it is a pre-plan attempt by the district administration.
No, I am asking you what is the why the show cause was issued to you?
Because of her allegation, lordship, because of her allegation that she is the owner of that property, the lordship collector issued this show cause. And
what the collector has.
And subsequently,
with the ownership of the property.
lordship, sorry, state of the affairs, lordship, for this, they have sealed my hotel for last 4 years.
So what the collector has to do with the.
And lordship kindly is the most.
The hotel is.
Lordship kindly, lordship, please come to press 34.
Where it is?
Balangir, lordship.
Is there any provision that if there is a dispute, they can close it or something?
They are doing everything, lordship.
No, I am asking.
No, lordship.
There is no rule.
No, lordship.
How the collector
Collector.
decide the ownership?
Lordship, kindly come to press 34. Lordship, what's the press 34? Lordship, kindly come. What he has done subsequently. Lordship, this case ended with this inquiry report, and the criminal case also ended with acquittal. And lordship, kindly come to for a moment one page.
What was the allegation in the criminal case?
Criminal case, lordship. Trespassing and this thing, lordship. That has been, lordship. Lordship, kindly please come to page 40, lordship. Page 40 and 41, lordship. I have given the order, acquittal order, and this deposition copy also, lordship. Lordship, page 40 and 41. Lordship, that is her deposition, lordship. In page 40 says, I cannot read or speak English. And lordship, in another is saying, I don't know, lordship, how to write in English, lordship. And the collector has taken entire action and seized my hotel. Considering the application is page 34, which is in English, and the signature also in English, lordship. So it is a politically, lordship, motivated decision, lordship. So now, lordship, my humble submission at this stage, matter is over, lordship. Now, lordship, they will take a decision on my renewal application. Other lordship, what they have done against me. Lordship,
Madam, what are you doing? How the proceeding can be initiated and all that? What provision of law?
Well, here actually, Malik, there are various proceedings which are pending also, Malik. There's order of excess commissioner which is challenged in a writ petition.
No, I'm asking that, just being a very civil side.
Malik, I understand the issue is basically.
I'm really trying to fathom upon that how the authorities are usurping the power. A person who is admittedly found in possession of a property, he is running the business there from some alien or an outsider who comes and claims a right of ownership in respect of a portion of the property, or let us go to the extent that the whole of the property. Admittedly, he is in possession. Is the excise collector decide the ownership of the property? Or it is a prerogative of this civil court? If it is a prerogative of the civil court, how can he initiate a proceeding? If there is a civil dispute on the right under section 34 of the Special Act, let him go to the court. How the collector started initiating? Somebody says trespass, you have issued a license much earlier. You know well better that I have issued a license with this property in the name of this. I have transferred this license in his name. So it is not a trespass for the first time, it is continuation. That knowledge is with you, till you have initiated the proceeding. I really wonder that how one can act on that. And if there is any provision in the rules which says that if somebody raises an objection on the ownership of the property or on the possession of the property, then the excise commissioner, if it is there, let me see the form.
Here we have to take a factory, because
How
they.
can you do it? I'm just asking, I
understand.
in extreme case.
I understand.
All of the property claimed by somebody else. But he's admittedly in possession and running.
Purely civil dispute.
The law respects possession. Even if there is no title to support it. Is a dictum of the Privy Council. Reiterated by the Supreme Court in AI 1968, Supreme Court 620 or a 420, I think 620. Right hand side page, left hand first column of the how authority can, if he is in the second position, without recourse to law, he cannot be a victim.
Well, he has not been evicted, what I can gather
Then
from.
how you can initiate a proceeding because you are not taking a decision of renewal on that score. That somebody has raised an objection on the ownership. He has not gone to the civil court. The criminal case ended in that he was not able to prove that there is any act of trespass. What more you want? Unnecessarily inviting a litigations in the court.
Various litigation against the collector's order and.
Sir, I mean, was it in relation to anything which impedes her continuance in the business?
They seal the entire
Or
ownership for 4 years.
which impedes the grant of license or a license?
Malik, this only Malik I could gather is that the matter is sub judice with respect to writ petition number 246, wherein the same challenges are made, Malik, that matter is
This matter relates to multiple aspects of single source.
Item 12.
My lord, I am appearing for a petitioner in item 12. Arguing counsel is not well. So may I request for a short adjournment to next week? My lord, any returnable date?
Adjourn to 23rd July.
Obliged, my lord.
Item 13.
Wait, please allow. Well, that's basing on a report by from the DPA. Assessment year 18-19 was reopened. In notice under clause B of 148A at Annex 3, page 31 was issued. I made an objection and being not satisfied, my lord, the assessing officer passed the order under Annex 4, page 33. A notice under section 140 reopened the assessment. Well, let's hear one thing. The assessing officer who received the report did not independently examine the veracity of
So this is to be open for what and because 148A is a preparatory provision for the purpose of 148.
And also, I have got a judgment of this honorable court says that ballots, the independent application of mind by the assessing officer and should not be swayed away. That also ballots. Of this honorable court. Ballots, para 9, I'm sorry. Ballots, very good ballots.
That is what probably.
No, I'm not there, man. Yes, very good, man. I'm not there also. I'm also not there about the faceless assessment by the jurisdictional assessing officer. I'm not also there. What happened, ballots? After the reopening, questionnaire notices issued that this questionnaire under section 142(1), the assessing officer has to conduct the inquiry. He sent us notices and I replied. Thus you will see Annex 9, the notice dated 3 July, page is 118. 2122 118 Annex 9. There, my lords, I was asked to furnish certain documents. Then, my lords, the annexes which were provided in the notice issued on section 142(1), I was supposed to give reply. Very good, man. Then, my lord, I replied, I furnished certain documents and asked for, now you will see the computerized that acknowledgement, I mean the response which I submitted Annex 10 at page 123. In response to your notice under section 142,
for the assessment year 18-19 attached.
Please find computation of the total.
Yes, yes, total income
Copy of
and
ITR, copy
Yes.
of the audited account and balance sheet,
yes,
copy of 26 years,
yes,
and purchase register, sales register, and all everything.
yes.
Fine.
Then my lords, I requested 1 month more time to produce the balance documents. Then my lords, no opportunity was given. Straight away, lords will see annexer 11, 1, 2, 5.
What is the time bound assessment to be done?
No, it was not there, matter.
Lordship, the assessment should be.
Just a minute. It is a reopening of assessment. Kindly please give me 2 minutes time more. What harm is there? You will reply. So, my lords, this is the most interesting part of this case. Lords, you will see Annex 11, so-called notice as to why the variation proposed should not be notice for variation. Then, my lords, will say the next page. Please turn to page 126. Para 4.1. This has reference to the assessment at 24-25. Yes, and this 24-25. We are for the assessment at 18-19, and he utilizes
Non-application of mine.
totally balanced. And he adds
And next
is
anywhere he has stated about it.
no, he has said that these are the I am going to make additions. Bogus purchase. This is you also will find at page 127 heading bogus purchase. Then my lords, which were never asked during the assessment proceeding. Then unsecured loan 21 lakhs. Then my lords, we'll see unexplained expenditure. Next page 129 unexplained money under section 169A.
They are not referring the year.
Yes, they are not referring the year back. And lords, you will see less than 7 days time was given to reply. As per the SOP issued by the department, own SOP, lords, you will see annexer 6 at page 39. You have 7 days time, and lords, you will see when the date was. Yes.
8.14.
Yes.
Page 12.
Yes.
That is the ground we have taken.
Yes. Question is, my lord, when you are going to assess me for the assessment year 18-19, yes, 24-25, how it can utilize those materials, which is ongoing.
Speaking of what? The typographical mistake.
It may be a typographical mistake.
Pariganda was not been issued.
Your lordship.
If that Pariganda would have issued, then would have.
Yes, he has a turn to answer.
Yeah. I bow down.
Yes.
I bow
Your
down.
lordship, first of all, it may be a typographical mistake, or in the assessment order, all the proceeding has been taken for the assessment year 18-19 only.
I understood.
And-
Why, if it is reflected there, then what does it mean? The moment you come to know, you could have immediately
Lordship,
or
another thing, it's a bogus purchase.
This is that. See, this has a reference to the assessment proceeding for assessment year 24-25.
Yes.
Please,
maybe your lordship, there may be assessment proceeding on the 24, 25 also. There was a
Please, sir.
bogus purchase.
No. Come.
Each assessment here is a separate and a distinct one. So he may be facing a 24, 25, but that is a separate proceeding. Then in that event, at the body, while you have said 17, 18.
The table, it is not typography.
No, I presume the lordship.
Table, and then ultimately at the conclusion, 17, 18.
Yeah.
So,
your lordship.
Yes, sir. All dates are linked. And you have not specified the period
Yes,
of this bogus purchase.
No, it's specified is 17, 18 assessment, financial year.
How can it be?
so what we just I find that here there is a mention of 17.
Yeah.
That is in 127 or 8 where he quoted the reply.
Page 127.
Simply quoted the reply.
Yes.
There only 17, 18, otherwise nowhere. You are sure. This quotation from there.
127 first paragraph. No mention about period to which that relates.
You not see in assessment page number 14 also.
How much is the demand?
The demand is 5 crores.
I will verify the record that have you got the instruction?
No, not see.
Have you verified the assessment record?
As per assessment record, I'm
Have you got any
I'll take an instruction.
instruction
I'll not receive here.
that these figures
You have already,
which are reflected in the assessment order?
we have already sent the stand for Paradise comment.
This is the mistake committed.
Already sent for Paradise comment, not yet received. And first time this matter
This
is
is only 3.14. Rest are the official documents. Rest are documents, all annexes. Only 3.14, I think that is the point which is legal.
And may I, with the lordship's kind permission matters, lordship will kindly see the date of issuance of so-called notice. That is my lord's 7/1/20. I
For suppression detected for 1 year cannot be.
Yes.
Another.
by Justice Sima Patra, yes.
I'm taking instruction, your lordship. This is related to 17, 18 only.
Sir.
Has to go.
Yes.
I'll take instruction, lordship. It should not be, it's a bogus purchase they have made during that year. And after that, they have not given the documentation.
When you use the word during that year, whether
17, 18, this, as per the assessment year, assessment order, even the notice issued. In all the, it's for assessment at 18, 19. And inside portal, when the so-called notice was issued under 148 AB, it was for the 18, 19 that as portal, the department given that these are the bogus purchase he had made. So for that notice was issued and assessment has been done. At best, I'll take instruction. Otherwise, he is an alternate remedy. He should take all these reports.
no, if it is apparent that on the face of it, it's not.
Definitely, your lordship.
Assistant business.
Yes. And he never given the supplied document which was wanting. as per the assessment report.
Supposed to revert in fact.
Oh, play.
Item 13 disposed of. Item 14.
My lord, item number 14 for RC cancellation. Item 14 for RC cancellation.
Item 15.
It is also RC. RC cancellation.
Who is there? I'm here, madam. For what? Giving a route for.
Sorry, madam.
You are obstructing him.
No, I'm saying.
Please give him. Yes.
Item 16.
Similar letter negative to both cases.
And the forward, sir, and university.
17.
Item 17.
Where is the difference? Kazo, this Kazo, yesterday was saying, that's why yesterday, where is that notification? I'm sending. I'm sending.
Get it printed out. You just get it printed out and
What is this note case? 70?
73 4 pages.
Item 18.
What is the next date?
13 July. 13 July.
All these dates will regenerate after the election.
13 July.
That's the reopening date, should not be on that, that will automatically go to the date after.
Item 18.
Item 18 cancellation of.
Document is up to him. This is applicant solution.
You have a copy.
Item 18.
The writ petition you give.
Item 18 disposed of. Item 19.
This matter relates to section 73.
19 and 20, 73 for people. What I.
And for.
Item 20. Send it in. WPC number 11554 of 2026.
We are disposing of.
In the light of the judgment which we delivered today.
The date will be first week of August.
Yeah, I have heard that that officer is on leave because of his
First
marriage.
week of August. Because now GST secondary filing is going on, so.
First of
August, first week of any date.
First of First. No.
Yes.
Since 99, I think.
All 6 matters disposed of. Item 21.
See, the item 21, it is an old matter.
Yes, item
I need
21, it's a very short issue, my lord. My
not hot issue.
very short issue.
Item 21, I am applicable.
You have not correctly assessed your formidable opponent. You will
Your
see
Lordship,
the short issue, I will make it more complicated and complex.
In fact, he was supposed to obtain instructions in the year 2023. Post that, there is no instruction that which is obtained.
Copy notes on.
Who are you?
Copy note one.
You are central. Is the state.
Your Lordship, I only pray one is time, Your Lordship. One is time.
Very short is that my GST's specific registration has been cancelled so moto by myself.
Not so much.
No, by inadvertent.
In all his applications.
Is the whole
Language, Your Lordship, the language and
this time first says that the cancelled by them.
By right one. The statute.
What he says.
By them. That is what I
The authority.
No. On his, Your Lordship, there is the difference. The only difference is that.
He has his own version. You may not agree with his version. Then you will get an opportunity to correct it. But can you prevent him that he should speak what your version is? How can you put your words into his mouth?
My version is
He's saying that it is cancelled by you. You say no, it is suo moto done by you. That's the difference. They have come before the court. We'll decide.
I don't see my obtain instruction. My short issue is that my GST registration was there. My GST registration was there. I have inadvertently cancelled it. The statute does not provide for reactivating the same because section 29 and 30, my lords are very well aware. It has to be done only by the proper officer. When it is been cancelled so moto by that petitioner applicant, the statute is silent. Therefore, my lords, I am praying before the authorities, my lords, to direct them to reactivate the cancel GST registration. That is the solution. My lords, my lords, there are judgments also, my lords. My lords, I will. But I'm passing on two judgments, my lords, of one of Allahabad High Court and of the Delhi High Court.
Any provision of PR or the law?
First one is the Allahabad High Court judgment. It's division bench. Case 3 is the relevant part. Are my respectful numbers. Merely because the progress
Should be, cut out from his government. What is the ratio of law he has to cut out from this?
That's merely because the
Delhi High Court says the authorities, they came forward and says that we have restored it. No decision has been taken thereupon.
Right.
So what ratio should I?
Allahabad High Court.
They have to admit.
Allahabad High Court.
Allahabad is a case of cancellation in that. And they says that there is nothing in the portal which permits for this. So why he should be deprived of this?
Same thing also applies.
The difference. One is the Lava case is non-filing of the return, monthly return, the cancellation of the second. And there they challenge not made that there is no motor I wanted to restore it. It is a case that you out inadvertently or by mistake wanted the cancellation to be done.
Inadvertently cancelled, my lords.
Who invited that please cancel my.
No, I did not invite. It was inadvertently cancelled by one of my junior employees. My lord.
Whatever I do not know, you conveyed your intention to cancel.
My lord.
Now what?
But the ratio is called out in the Allahabad High Court last paragraph, my lord, because
Read that paragraph.
the restoration
Simply
my lord,
says there is nothing, no icon in the portal, there is no provision.
it says
It was provided.
it might be permitted to place that paragraph, my lord.
Please place
My
it.
lord, it is, I read, my lord. In case the submission of the landed counsel for the respondents are accepted, the same in our considered opinion will amount to travesty of justice. The contention that there is no provision for restoration of GST registration, once it has been cancelled, borders on the absurd. It has been cancelled on its own. The same thing applies to me.
No, not by the SSC. Not by the SSC,
By the department.
by the department.
And have you ever approached?
Approach, multiple.
Where is the application?
My lord, there are applicants. I'll show.
Under 29,
Don't-
30.
My lord, 30 also will not come up because it is not cancelled by the proper officer, my lord. That will, 30 will be only coming up.
There is no provision for restoration.
There is no provision. That is the sole
provision of
Vocation is there.
30, section
30.
30.
Where is your application?
My lord, it's there, my lord.
Where is your application?
My lord, it's at Annexure
When is
C.
cancelled?
My lord, it's 2018.
28.
18.
When have you approached this court?
On 20, I had approached it on 21. My application was pending before the authorities in 2018, my lord.
Where is that?
That's Annexure 3, my lord. That's Annexure 3. My lord, it has been indicated that my lord, one of the June. My lord, it's mentioned, my lord. My lord, it's, my lord, on the basis of the generation of the above ARN, we have updated the same on our computer. Paragraph 2, my lord. Now you are unable to log into GST website for uploading tax invoice.
So there is a delay.
Delay. And thereafter, my lord, the subsequent phase, in the subsequent.
There is specific period in which you have to approach.
My lord, that applies only when.
Approach for within a prescribed period. That means during that period you never attempted to file any returns. You are conducting a business during that time.
Yes, my lord, business was.
How could you? Without uploading any return? And invoices, I think invoices you have not done that.
Invoices, but even.
You are supposed to upload
My lord,
3D returns.
my lord, let me come once again to Annexure 6 also, my lord. For a moment, Annexure 6. Annexure 6. my lord. It's a representation was submitted, my lord, to the authority. 2019, my lord. Subsequent follow-ups also, what I meant.
Why don't you file response?
Your Lordship, I'll find. It is another peculiarity, Your Lordship. He has applied for cancellation and he has applied a new registration.
It's fine. How I can.
From 29.
No, you can't.
Your Lordship, I'll only, Your Lordship, I'm very sorry. I'm.
Without producing a record, without.
Your Lordship, I'll pay. At the beginning, for that reason, Your Lordship, I pay time how this matter has been escaped. Your Lordship,
Sufficiently you have taken.
Your Lordship, Your Lordship, only 1-2 adjournment I have taken, but time. Your Lordship, only 1 week. Only 1 week. Only within 1 week. Your Lordship, I'm begging pardon. And Your Lordship, I can
I can prove your lordship. There is multiple fraud, your lordship. How this case of your lordship?
File affidavit.
2017, your lordship, I'll.
Getting file an affidavit, we'll file a count.
Yes,
It's under also, my lord, draft is taken up for hearing.
Your lordship.
Adjourn to 30th July. Item 22.
Lordship, I am appearing for the petitioner in item 22, Lordship. Lordship, the petition is filed challenging the portion of the circular issued by the CBIC and also the order passed by the appellate authority, Lordship. The issue, Lordship, is Lordship, inverted duty structure. I am Paradeep, Lordship. I manufacture fertilizer. My output is 5%. My inputs are, Lordship, 18%. So, Lordship, in the initial period of GST, Lordship, 17-18, I filed the refund claim for inverted duty structure as provided in CGSTX, Lordship, section 54. The initially, Lordship, they said that you are eligible for inputs and input service refund, formula provided for that. I claimed the refund. Refund was granted, sanctioned to me. Subsequently, Lordship, they amended the rule retrospectively to say that you are only eligible for inputs refund, not input services. I challenged that portion of the amendment before the High Court.
No. Amendment has only the filed.
You are not pressing.
Lordship, I filed the.
Are you pressing it?
Yes, my
It
lord.
is not. Has it been allowed?
No, my lord. Amendment not allowed.
My apology, Lordship.
So you will proceed in absence of an amended pleading?
No, my apology, Lordship. I filed the application for the.
So then the application has to be heard first. If you are permitted to amend, then they will definitely. What amendment you want to bring?
Lordship, the application is to make an official prayer, Lordship.
Around 35 pages. Amendment itself.
No, the consolidated petition.
Along with amendment, they have filed the
Consolidated petition.
That should be.
Lordship, amendment is to.
There is a judgment of the Supreme Court, 2002.
Lordship.
It says that you'll have to annex the copy. And the mode has also been incorporated. That you'll have to strike down if any statement you want to strike down with the black ink. And then in the red ink, you have to incorporate the amendments which you want to bring. It should be done in that way.
Lordship, I may be permitted, Lordship, to make the changes according to Lordship.
But here our approach is something different.
No, the reason is because the Supreme Court indicated the reason that if the matter then comes at the latter point of time, this consolidated petition will not contain the original statement which was allowed to be deleted. So in that event, if those are there, then it will be able to understand that why the amendment and how the parties have changed.
What was that prior position? What is the
What is the amendment he wanted to bring? What amendment you want to bring?
Lordship, I taken a ground, Lordship, in my petition that the entire amount which I paid should be refunded because the order itself says that the show cause notice is without authority of law, etc. Therefore, the prayer is, Lordship, to grant entire refund of 18 crore.
So you wanted, what you have already made a prayer in prayer A, you have asked for.
Lordship.
Oh.
Lordship, I restricted earlier, Lordship, to the.
Yes, B, directing the opposite party to refund the petitioner's sum of rupees 11 crores and odd.
Lordship, yes. Lordship, that's
so that prayer is already there.
That's an alternate prayer, Lordship. Because, Lordship, if I succeed on the circular portion, I am getting 11 crore, but the order itself is paid in law. If that is done, Lordship, then I am eligible for 18 crore. That's my additional prayer, Lordship, before this. I have taken the ground in the petition, Lordship, originally also, that the order itself is beyond jurisdiction as held by the appellate authority itself, Lordship.
Lordship, it is at.
Have you got the copy of the amendment? Where is the amendment application?
Lordship, it is at flag A. IA number 409 of 2026.
Page 4 is the schedule of page.
Oh, he wanted to challenge that order dated 27/11/24 to be quashed.
Lordship, I had two prayer lordship before lordship. One is this lordship, another is circular lordship.
Base 26, para A24, it will be clarified, my lord. Because in his pleading, my lord, he has stated that he is only entitled for 11 crores somewhat, 11 crores 77 lakhs 5,976. And in that way, he has designed his prayer. Now, he is coming with this amendment and he is committing that he is entitled for the entire 18 crores, my lord. More, my lord. And another part in background of this writ application, another writ application was there in which he has challenged the order in original and which was dismissed by this honorable court. Therefore, they have filed SLP, my lord, that has been dismissed. On review, my lord, an indulgence has been extended to them to file the appeal. And they have preferred the appeal. Again, against the order in appeal.
Review of?
Review of before this honorable.
After SLP is dismissed.
After dismissal of SLP, they have reviewed of the order part, the dismissal order part in the writ application, in the earlier writ application.
So in review, opportunity was granted.
Granted to file an appeal. Again, in order in appeal, my lord, they are before your lordship.
Lordship, the reason lordship is lordship reason is lordship the after this review was allowed, I filed the appeal. There is an amendment to the rule lordship, and that amendment is held as prospective by the
So
circular issue.
why you are not resorting to the statutory remedy available thereat?
Lordship,
Why the writ court as an exception should take up?
My lordship, my submission, lordship, I challenge the circular lordship. For that lordship, there is no alternate remedy as held by the lordship in the number of
Where you have asked for a circular declaration of the circular?
lordship. My prayer lordship is there in the original petition, also in the amended petition lordship. Lordship sees my prayer as C lordship.
Prayer C.
Lordship.
Prayer C is simply you do not want to quash it. You say it's a clarificatory and it is to be, is not a clarificatory and it has to be applied prospectively.
No,
So
lordship,
it's a question of law. So the appellate authority can decide whether it
circular specifically held lordship that it is for prospective, not retrospectively. That portion I want to challenge lordship. That's my prayer lordship. And lordship, very same circular challenged by the Gujarat High Court and that is affirmed by Supreme Court lordship. There are 3 more high courts on this very circular lordship that it cannot be retrospective. It is retrospective. It cannot be prospective.
that judgment you can rely upon before the second appellate forum. They will take care of this.
Lordship,
they are bound by that judgment.
I am before the lordship, the circular
No, why should we? Why every case should be considered?
Lordship, I am challenging the circular, my lords.
No, it's not a question of
as my prayer, lordship, then the lordship alternate remedy.
You wanted the characteristics of the circular, whether it is clarificatory or otherwise, whether to operate prospectively or retrospectively. It's already decided, not a quashing of the circular.
Lordship, that is done.
If a declaration is sought, I can
amendment
understand.
they made, lordship. Amendment they made in 2022. That amendment, the circular says is a prospective. That portion I am challenging the circular itself. That it cannot be prospective.
There is no prayer. There is no prayer that the circular is bad or to be quashed. You simply say the applicability or operationalization of the circular, whether retrospective or prospective, which if a judgment has been delivered by other court, the tribunal will take into consideration to apply prospectively or retrospectively. Go before the tribunal.
It says, lordship, to quash to the extent it clarifies the amendment is prospective and not clarificatory.
That is what I'm saying, the nature you wanted, that can be done by a authority,
But
there is
the
no
Lordship, there are-
difficulty. If you want a
circular
quashing,
challenge, Lordship,
I can
cannot do
understand that
this.
the circular has to be quashed.
Lordship,
Then we can understand they cannot do it.
Lordship, the
What?
circular Lordship I can challenge before Lordships in the writ remedy Lordship. There is no alternate remedy for the circular to be challenged.
What is the nature of the circular that the tribunal
Kindly see the
can
circular,
decide
Lordship.
whether it is clarificatory or it is something new?
Lordship, kindly see my circular for a minute, Lordship.
Prospective. That
Page
amendment
59
is
of
prospective.
petition,
Only
Lordship.
issue is
If a judgment of the Gujarat High Court has said something differently, then
No,
the
my-
tribunal is bound by it.
obviously, my lord. One
No,
is
Lordship.
Let them go and decide. Relegating them. You file your appeal. Disposed of appeal.